Right, so thanks a lot everybody for coming along to that this morning, getting up so early when it was quite cold outside, and thanks a lot for the invite to speak tonight from the CETA and the SCSI. I am a senior associate at Beale and Company. Obviously we've got offices in London, Bristol, Dublin and Dubai. I'm based in London, but I spend quite a lot of time supporting the Dublin office. I guess the main reason I'm here is because I am what you might call Beale and Company's BIM guru, just because I've been spending quite a bit of the last 6 or 7 years considering some of the legal implications of BIM and trying to work out ways of reflecting that contractually. Initially I got involved back in 2012ish, I think, in drafting the CIC protocol for the UK government task group, essentially, as part of the original BIM mandate over in the UK. Obviously, it's a really exciting time for BIM over in Ireland as well, with the digital roadmap. And in my view, this is a real opportunity to try and shape and model how we want the industry over here to be approaching BIM, and to maybe try and learn from some of the lessons that have come out of the UK approach, for example. So I'm going to have a look at some of the key risks of BIM from my perspective. I should have said I'm a contracts lawyer, so I'm focusing on those risks and also how you could address a lot of those risks in the contract, and those risks range from, in my view, what does BIM mean on any one project, or what does it mean generally, the various ambiguity that could arise from the use of BIM in terms of what the deliverables are, and the use of common data environment to share information, where we sit in terms of intellectual property and BIM, the potential software issues that could arise from the use of BIM, and in particular interoperability, which is not so easy for me to say, but we'll come on to that later. The importance of confidentiality and security, which is something that's quite easy to forget when you're using BIM and you're exchanging a lot more information than you might have done otherwise. And just, I guess, the general comment or the general consideration of trying to avoid inconsistency between a contractual approach and the actual approach that's taken on the project team. And I guess that's probably going to be a theme of my talk today, is trying to get somewhere where the contracts and the procurement documents are joined up with what the approach is in relation to BIM. And it's something that I see far too often, that I'll be sent an EIRs or a BEP and saying this says that we're using the CIC protocol, or this says that the models are deliverables, and then I'll also look at the contract and there'll be nothing about BIM. So it's almost there's an intent from the project team to try and use BIM, but there's no real teeth to it. And it's a really important point. If we're going to get the most out of BIM, it needs to be something that is a requirement. So it's something that Gary mentioned a few times in his talk, but BIM is unfortunately not something that you can really just buy off the shelf, although a lot of clients will try and do that. If you want BIM, you need to say what it is you actually want, i.e. what the outputs are that you want from the use of BIM. It's very common that tender documents will just say you will deliver BIM, you will deliver level 2 BIM. Even level 2 BIM, it's not a defined legal phrase. There was a bit of a debate on Twitter over the last few days about what level 2 BIM meant and whether it meant that you had to provide COBie data or not. And there are so many different opinions. It was ridiculous. The point is, if a client wants BIM to be used and wants that to be a benefit after the project is finished, the client needs to say exactly what they mean by that. What are they expecting the project team to do? What deliverables are they requiring? And as Gary was mentioning, what exactly are the client's employees' information requirements? It's a bit of an unfortunate position, really, because from my perspective, BIM seems to be driven by the consultants and the contractors and the supply side, whereas for BIM to really work, you need the clients to be driving it and specifying what they want and telling people what they want to get out of it. I think, as Gary mentioned, there's definitely a niche there for consultants and contractors who are prepared to tell the clients, this is what we think you need at the start of a project, and try and get them up to speed and almost design the employees' information requirements for them. But that's an important part of the process. And the problem is, or the risk is, if you don't make that clear at the outset, and you just say, okay, we'll deliver BIM at the end of the project, the client might say, oh, actually, I didn't want BIM, I want like that. I did want COBie deliverables. I did want you to send me the 3D models, which is when that wasn't something you're expecting. So it's just something that's really important to try and define as much as you can. The other key aspect in relation to BIM is having clear lines of responsibility. And that is really because BIM involves much more wider exchange of information, a lot more sharing of information, and often you may have two people working on the same model. Because of the fact that information is more widely shared and more readily accessible, it's important to try and agree who is doing what at the start of a project, as it is on any project, but it really is emphasised by the use of BIM. An example of that is the appendices to the CIC protocol, i.e. essentially a design responsibility matrix saying who's responsible for which elements of the model, when they're expected to be sharing certain elements, for example. The other aspects of responsibility and the sharing of information is the role that the common data environment plays on any project. As I'm sure a lot of you are aware, essentially the common data environment is where the information is being shared, or the vehicle that's used to share information. And there are various states of information in the common data environment: work in progress, shared, published, and archived. That might be fine as a working method, but quite commonly that process is in place, and then a client will say, oh, I want to look at all your work in progress and take that away and see what you're getting up to. And that may not be something, that's obviously not something that would have been anticipated at the start of much projects, and that work in progress may not have been, for example, quality checked as much as the shared or published information. So it's important to clarify at the outset of a project where BIM is used, what the role of each of those different parts of the common data environment is, what the access to that information is going to be, and how models in the common data environment can be used. And typically that's done by using status codes, for example, which say this information can be used for this particular purpose, and also being clear to what extent any particular model or information has been developed when it's shared, by using, for example, levels of definition or level of detail, to be clear that this information has only been developed to level of detail 3, so should only be used on that basis. for example. It's just really important that you are clear as how all this is going to work at the outset of the project, and that processes are in place so that the whole project team is working on the same basis. The other key area in relation to the common data environment is really having a good understanding at the outset as who is responsible for the common data environment, essentially. And I guess this is really where the one reported case in relation to BIM came about, Trant and Mott MacDonald. Essentially, Mott MacDonald hadn't been paid, and so decided they wanted to walk away from the project. And when they did that, they took the access code essentially to the common data environment and said, no, Trant, we're not letting you get any of the information anymore. Essentially, the court held that Mott MacDonald couldn't do that, and they had to give the access to Trant, essentially. But I guess that one of the main points to come out of that case is that the dispute really arose because there'd been no formal appointment of Mott MacDonald. There'd been a bit of an exchange of fee proposals, and they hadn't really agreed at the outset a clear process for who was going to be responsible for the common data environment when this access code could be or had to be held who held the access code, essentially. And it just underlines from an employer's perspective that they need to be the one holding that access code as much as possible. So intellectual property, a common point or query that's raised in relation to BIM, and it was something that was mentioned earlier, is who owns the model. And it's really important to be clear on that at the outset of any BIM project. From my perspective, the approach to intellectual property ownership when you're using BIM shouldn't change much from any typical project. You should still be able to operate whereby the project team license the use of their information to a client to use it for specific purposes, but it's just important that those licenses do clearly include all BIM information, so that there's no gap between what is being licensed and what is being shared. And if a client does particularly want to take ownership of that information, that's obviously something that needs to be reflected in the contract. And the project team need to be prepared to accept that position, i.e. if they assign ownership of all their intellectual property, including in their BIM information, that they're essentially handing over the right to reuse that information, and they could be losing a lot of value in doing so. Another key area in relation to intellectual property and BIM, which I mentioned earlier, is being really clear what the purpose for which any models and BIM information can be used. And I mentioned previously that BIM information will typically include status codes, levels of definition, and it's trying to be clear that the purpose for which that information can be used is tied into those status codes and those level of definition. And that's the approach that's taken in the current CIC protocol. Otherwise, the standard approach might be our information can be used for any purpose for which it was prepared, which is fairly vague and open-ended. So I guess the main point in relation to how BIM impacts the intellectual property is just having as much clarity as you can as to what purpose information is being shared for at any time. Another interesting point or relevant point in relation to BIM is the basis on which members of the project team are able to use each other's information, i.e. if the architect needs to access the engineer's model, do they have a right to do that, or is there a risk that they might be breaching the engineer's intellectual property. It's something that's not usually clearly catered for in contract documents, but I think it is something that's important when BIM is used. Generally, the reason why it's not catered for is because there would be almost an implied license between the project team to use each other's information. But I think because of the increased information exchange when BIM is used, it's something that is important to think about. And in the CIC protocol, for example, there are licenses granted from the employer to the project team to use all the other information, all the other project team members' information for the specified purpose. And that's just to create a really clear framework setting out how information can be used. Another implication or key legal risk arising from the use of BIM is really the role that the software plays in terms of any additional risk. Obviously, BIM is more than just software. It's about process and about the culture on a project. But software does play a key part of producing the outputs. A common anecdote that I heard in relation to BIM and the risk of software use is that when, for example, the engineer shares information in one particular format and then sends that over to the architect for use in a different format, that there will need to be some form of conversion from the architect's format to the engineer's format, so that they can both speak to each other, just because for historical reasons I think different members of the project team typically use different softwares, and those software, that software doesn't always speak the same language. And because of that need to transfer the information, there is a risk of the information changing or the data becoming corrupted as you transfer it from one format to another. I mean, as I said, the anecdote I heard was that after that transfer, all of a sudden a beam that was meant to be in the roof was suddenly focused on the floor and angled downwards, which was an obvious error and could be picked up. But it's something that just needs to be thought about carefully at the start of any project, and essentially procedures need to be in place to try and avoid these sorts of risks arising. I think an approach they took on the Crossroll project was to say, to avoid this, we're going to say everybody has to use exactly the same software format and exactly the same version of that software format. I think that's perhaps a bit extreme. There are other ways of trying to avoid this risk. Things like Open BIM and IFC formats, so that you're sharing information in a format that is not vendor specific, that anybody can access it, and it should reduce these risks. And that's really why these processes need to be in place. And the other point in most is that generally these software companies are fairly large firms, often US firms, and they have very wide exclusions of liability in their terms, and there's very limited scope to negotiate those terms. So if an issue arose that was solely due to the software being used, it's unlikely that the architect or engineer would have any right of recourse against their software company. So it's an important point to bear in mind. Are you prepared to take that risk, or do you want to exclude liability for those sorts of issues in your contract? It's something that is addressed in the CIC protocol. Essentially, each project team member excludes liability for data corruption and essentially anything that happens after they issue the information, so that they're not taking that risk. Security and confidentiality is another important area and potential legal risk arising from the use of BIM. as I said, BIM involves increasingly, or the increased exchange of information, and I mean from demonstrations I've seen, the amount of information that a BIM model will contain is quite bewildering when you look at how easily they can drill into the models and all the different aspects of it. I guess the point is just to make sure that you have that there are processes in place so that if you copy something from the BIM model on one project into a BIM model on a different project, that by doing that you're not disclosing or you're not sharing confidential information in relation to the original project or the original client, and that the only thing you've got in that BIM model is what you actually need on that particular project. And similarly, because of the increased exchange of information on any BIM project, it means that there's increased access and an increased risk of that information getting into the wrong hands. An example that I've heard would be, I think, possibly there are some Chinese contractors out there, or Chinese contractors that will tender for work just so they can essentially access the intellectual property in a design, and even if they're awarded it, they won't actually be there to do any work. It's just a way of them trying to obtain intellectual property and access information which they shouldn't really have had access to. So essentially, it's something that there is one of the PAS documents, PAS 1192.5, particularly focuses on security, and it's something that is really important to have in the back of your mind on any BIM project, so that you've got some procedures in place to address these risks, and also that the project team is required to actually take those into account during the project. I guess the other risk in terms of data loss and security is also an understanding in terms of your organisation where you sit. If, because of the way you've accessed the information, there's a big hack in relation to a particular project, or a big cyber risk, which, for example, causes the whole model or the whole commendation environment to crash or disappear, would that sort of liability be covered by your professional indemnity insurance? And also, do you have cyber insurance in particular, which is particularly aimed at that sort of risk? If you're not clear on the insurance position, you really need to make sure that there are processes in place on any project so that if that sort of hack occurs or that sort of issue on the commendation environment happens, that everybody's got backups and that you're not just dependent on one copy of all the information. So, how is BIM typically reflected contractually? As with tenders, unfortunately, it's not normally reflected particularly clearly as a matter of course, and the main bugbear is that the position in the contracts is often not consistent with the actual BIM processes that are in place, i.e. the deliverables won't be consistent with what the project teams agreeing to provide, which could mean that the agreements the project teams are making have limited teeth. Earlier this year, the Winfield Rock report was published, which essentially outlined that there is a real gap, I think, in terms of the contractual approach to BIM, and probably generally lawyers' understanding of BIM and how they reflect that in contracts. Just for a key area would be that there are various different understandings of what BIM meant, and I think a lot of lawyers were not really clear what they needed to do to actually reflect BIM. in a contract, just because I think there was a bit of a perception amongst a lot of lawyers that BIM was just a software, so it's not something that they really needed to think about too deeply. Obviously, the risk is if you don't properly reflect BIM in a contract, there'll be ambiguity or inconsistency between what the client's expecting and what the project team's required to provide, which is more likely to give rise to a dispute. And it also could mean that the client doesn't obtain the true benefits of BIM. And I guess, just as another note, it's not something that I've seen mentioned in Irish construction contracts that I've reviewed. It seems to be something that needs to grow over here as much as it does in the UK. Trying to get the legal industry understanding how BIM should be reflected contractually and what they need to do about it. So, what is a typical approach that you could take to reduce some of those risks? Obviously, as I said, making sure that intellectual property rights cover models is an important point, but that's just one element of it. You need to do more than that. You also need to be clear that the scope is consistent, that all the risks that that I mentioned previously are covered in terms of risk of software issues, and also try and have a contract that encourages or at least takes into account the fact that this is if BIM is used, there's going to be an increased amount of cooperation and collaboration between the project teams. So trying to have some kind of process for resolving any issues if they arise during a project, or if any ambiguity arises, and trying to encourage the project team members to actually collaborate on a regular basis. Those are all things that are included in the CIC protocol, the second edition of which was published earlier this year. The CIC protocol is something that can be easily incorporated into any contract, and it is intended to be incorporated into every contract on a project of the whole project team. It basically, on the most part, just piggybacks onto the underlying agreement by adding in provisions in relation to BIM and obligations in relation to BIM. It's a document that's available online, and there's a link on there, or if you just Google for it, you can easily find it. But just using the CIC protocol in itself, it will only address the legal side of things. As I said, for BIM to be properly addressed contractually, it needs a joined up approach, and the CIC protocol includes two appendices, three appendices actually in the updated version. The responsibility matrix, essentially the information particulars, and the security requirements. Unfortunately, it's quite common that I'll see a protocol included in a contract, but none of those appendices will have been completed, which essentially means that there's no real teeth to what the parties have signed up for. So it really needs to be a collaborative approach between the lawyers and the project team to make sure you have been properly reflected in a contract. Obviously, with the BIM roadmap recently announced, it's a very exciting time in Ireland in relation to use of BIM. And as I said at the start, I think this is an opportunity now to try and drive good practice in terms of how BIM is reflected in procurement and how BIM is reflected contractually, just to, essentially to reduce any ambiguity that might arise and to try and make sure the clients are obtaining the benefit that they want from BIM. So I'll be really interested to see how that progresses over the next few years. I think we're having a Q&A session straight away now, so at the end. Okay, yeah, there's one more speaker, but if anyone's got a burning question now.
Can you just hold the questions over to the panel?
Okay.